Hi guys, welcome back to this OCR A-level Law revision series. Today we're moving on to paper 2, section A of the specification. If you missed my paper 1 walkthroughs, the link is in the description. Anyway, let's get started. So the first topic that comes up is parliamentary lawmaking. So the first sort of subtopic in this topic is influences on Parliament. So one influence on Parliament is political influence. So before a general election, all parties publish a manifesto. Parties that get the most MPs elected become government, and they have up to 5 years to bring in these promised reforms. However, they're not legally binding. Positives from this is that it's the electorate, so you have the political will of the people, and they've chosen the reforms. However, constant change of parties in power can lead to costly and regular law changes. Also, if the government has a small majority, as seen in the 2010 to 2015 coalition government, it can be restricted in the laws it wishes to make. Another influence on Parliament is the media and public influence. So the government may bow to strong public opinion promoted through the media. Positives from this is that it has public input. Also, the public are more aware of important issues. However, there is fake news. Newspapers have political biases, and it can lead to poor legislation. Another influence on Parliament is pressure groups. Uh, these are a group of people working together to try and influence what other people think or what the government think about a particular subject in order to achieve the things they want. So there's two types of pressure groups. So you've got sectional, which they represent interests of a particular section of society, for example, the law society, for like solicitors. And then you've got cause pressure groups who promote a particular cause, for example, Greenpeace for like climate change. Now, they have limited success. An example that's quite famous is the Fathers for Justice with the royal kidnappings. They lost public support. But however, there are some successful examples. For example, the Stonewall LGBT, the Sex Offences Act 2000 amendment, which saw consent for homosexuals increased to 18. Some positives from this is that it gives public genuine say in reform for law, and it makes politicians accountable to the electorate. However, it can lead to poor law being made as like a knee-jerk reaction, and also it can be difficult to get momentum if the press do not pick up on your calls. Lastly, we've got lobbyists. These are people who try to get MPs to support their cause. They get their name from the fact that the public can meet MPs in lobbies, like the hallways of Westminster. Any individual can lobby their MP, however, most lobbying is done through professional lobbyists on behalf of big businesses, trade associations, and charities. Now, positives from this is that MPs are accessible to the public. However, most successful lobbyists are paid by rich and powerful organisations who are pushing their own agenda. Also, some use dubious tactics like bribes to persuade MPs to promote their law. Now, one thing that might come up that isn't directly quoted in the specification is the Law Commission. However, this will probably come up in your exam, and it's good to know about it. So, the 1965 Law Commissions Act made the Law Commission a statutory independent body. It was designed with the purpose of keeping the law of England and Wales under constant review and to recommend reform where needed. The aim is to ensure the law is fair. It has a chairperson, researchers, the Lord Chancellor, and it also employs other various staff. In the first 10 years, it had an 85% success rate. However, there was a lack of reforms after, as MPs kind of just ignored their recommendations. Another positive is that the Law Commissions Act 2009, it meant MPs must give reasons to not enact their reforms, which led to an increase of 65% success rate for recommendations of reform. Hence, it's not binding on MPs to act on advice, it's just very hard to ignore, and they're experts, so they usually follow it now. The job of the Law Commission is to repeal, so this means to get rid of old law. Codification, this means putting all sources of law together in the same place. And consolidation, putting all acts of law in one statute. Then you've got the legislative process. Now this is how laws are made, what stages they go through in Parliament. So these are either going to start out as green paper bills, white paper bills, or private/public MP bills. Now these bills will have a first reading in the Commons. Then there will be a vote to proceed. Now if that's successful, it'll go to the second reading, also in the Commons, with another vote to proceed. Now if that's successful, the bill will go on to the committee stage, where in the Lords, all Lords have to attend, where in the Commons, only a select number of MPs have to attend. Then you've got the report stage, where everything is taken into account. Then there's another vote to proceed. Now if that's successful, you go on to a third reading, which is a formality really, as they've already passed it through the first and second, and also the committee and report. So yeah, there's another vote to proceed. And then in the Lords, they have to go through the same process. Sometimes there's a ping pong, so it might pass through the Commons, but the bill will fail in the Lords. But the powers of the House of Lords are limited by the Parliament's Act 1911 and 1949, so this rarely happens. Then you have to get royal assent for the final bill. And then once this has approval of both the Houses and the Queen, a commencement order to bring the bill into effect occurs. So this means the bill becomes an official act of Parliament at a later date. As mentioned beforehand, you've got different types of bills. So you've got a public bill, which involves matters of public policy and impacts the general public. You've got a private member's bill. This is introduced by a private MP. You've also got a private bill, which affects a particular person, organisation, or place. You've got a hybrid bill, which is introduced by the government, but affects a particular person. And then you've got government bills, which are pretty self-explanatory. Evaluating parliamentary lawmaking, starting with the positives. The Parliament makes the law in a democratic way for elected members. The law-making powers may be delegated to other bodies, meaning complex law can be made by the relevant experts. Suggestions for new, simpler and clear legislation often come from the Law Commission. The bills are highly scrutinised, so there's votes, debates, committees. This means that they are balanced, objective and thorough, so all sides of the debate are included. Also, since 1997, all acts are accompanied by explanatory notes, so this is great help to all of those trying to access the law. Now, for the negatives, it's not really true democracy, which would be impossible as we would have to vote on every law. The government undertake too much legislation, almost 3,000 a year on average, so changes in the law are not well known, so some people could still be prosecuted based on old laws. The Parliament is not bound to follow the advice of the Law Commission, evident in relation to the LOC in CJ 2009. Due to the restrictive timetable, the government often forces through Parliament legislation. So in the committee stage, the membership of the committee isn't specialised, so there is little time to cover the whole bill. And lastly, the language used in many acts is too complex because draftsmen try to provide for every eventuality. Moving on to the next topic, delegated legislation. Now, delegated legislation is the law made by a person or organisation other than Parliament, but with the permission of Parliament. So, who can make laws? So, the Queen and Privy Council, and the type of legislation for that is the Orders in Council. In times of emergency, transfer of responsibilities, changing amending acts, European directives. Local authorities can also make laws. So this including public and professional organisations. So they make bylaws used to deal with issues in their own area. So, for example, the Dogs Fouling on Land Act 1996, parking restrictions. Government ministers also make new laws. Now, their type of legislation is called statutory instruments. These are rules and regulations concerning laws. They make around 3,000 average annually, and some SIs apply to the UK, and some just England and Wales. Now, this applies to government ministers and their departments. They can be used to update the law, also for commencement orders and European directives. The next subtopic is controls of delegated legislation. So, one control is Parliament. This comes under prevention. So, one way Parliament controls DL is through committees. So, Parliament has a number of committees. For example, they've got HOLD, Powers Scrutiny Committee. So, all bills which delegate powers are examined before they begin passage through the House. Another example is the Joint CNL Committee on SIs. Another way Parliament controls DL is through writing a very good enabling act. So this is to strictly outline the areas within which the DL can be made and procedures that must be followed. Also, they can have resolution procedures, so SIs. So you've got two types of resolution procedures which are normally added onto the ends of bills. So one of them is affirmative yes resolution procedure. So the Parliament must debate and vote to approve SIs before they will become law. They only accept, reject, but cannot amend. Also, there's negative procedures. So they become law without a debate or vote unless opposed within 40 days of being laid before Parliament. The other control of DL is the courts, which is referred to as a cure. So all delegated legislation can be challenged by a person/body with sufficient interest or standing through judicial review in the administrative court, which is part of the QBD High Court, on the grounds of procedural ultra vires. So this is Latin. It means where the body has not followed the procedure set out in the Enabling Act. So the case for this is Aylesbury mushrooms. You've also got substantive ultra vires, where the body is acting beyond the powers granted to it under the Enabling Act. So the DL is void because it goes beyond what's permitted. So the case for this is Bromley LBC v Greater London Council. You've also got unreasonableness and human rights. So DL is challenged if it's so unreasonable that no reasonable body would have created it. This comes from Wednesbury Unreasonable, a case in 1946. DL also challenged if it contravenes human rights according to the HR Act 1998. Now, if you forget some of these cases, specific cases, a good one to remember is Miller v PM. This was quite recent. It involved the Brexit Prorogue challenge. Moving on to the evaluation of delegated legislation. So starting with the positives, all types of DL save parliamentary time and money. 3,000 SIs made per year, and Parliament simply don't have the time to create these numbers of statutes. Secondly, it allows Parliament to concentrate on broader issues of policy rather than masses of great detail, which lets them address issues which affect the whole country more often. It allows for rapid action in times of emergency. Lastly, local people understand local needs, so the Parliament will not have the knowledge to, for example, make local parking restrictions and other laws where only local people know where they must be enforced. Moving on to the negatives. Firstly, it's undemocratic as it's made by unelected people rather than MPs. It isn't a problem for bylaws as local councils are elected by locals. Secondly, there's little publicity compared with Acts of Parliament. This may mean people are unaware the ruling exists. As mentioned already, there's 3,000 SIs each year, which makes it hard to keep track on all the legislation, as it takes up a lot of time, which kind of defeats the point. Lastly, control by Parliament is not always effective. There's very few affirmative resolutions, and MPs are too busy to look over them, and controls are often not used anyway. The next topic is statutory interpretation. So the first subtopic in this is rules of language. So the Egistem generis, things of the same kind rule. This means when there's a list of specific words followed by general words, then the generals are interpreted in line with the specifics. So the case I use for this is Hobbs v C.G. Robertson Limited. Another rule is the expressio unius exclusio alterius. I know I've butchered the pronunciation of that, but we'll go with it. This means the express mention of one thing excludes others. So when there's a list of words not followed by generals, the act only applies to items on the list. So I use Tempest v Kilner for that. And then I'm not even going to attempt to pronounce that. That means a word is known by the company it keeps. So words must be looked at in context and interpreted accordingly. So I used Inland Revenue Commissioners v Freer for that one. Aids to interpretation. So firstly, intrinsic aids. This concerns matters within statute itself that may help to make its meaning clearer. So the court can consider a long, short title, for example, the preamble. This sets out Parliament's intentions. The Theft Act 1968 can be used for this. Some acts have an interpretation section also. So for example, again, using the Theft Act, property includes money. Sometimes the interpretation section will give an extended meaning to words. So for example, again, using the Theft Act, building includes an uninhabited vehicle or vessel. More intrinsic aids include headings, schedules, marginal notes, explaining sections. Even other sections of the Act can sometimes be used, as seen in Harrow v Shaw. Evaluating intrinsic aids. Now, firstly, with the negatives, modern statutes don't have preambles, so the help of IAs aren't in every statute. Headings may not reflect Parliament's intentions also. And lastly, definitions are not always included, which leads to uncertainty, as judges are forced to interpret case law. The positives are that once placed in statute, the law is clearer, it's easier to distinguish. This means it's more likely to come to interpretation Parliament intended. Secondly, they have definition sections, so what's meant by certain words, phrases. Also, the preamble is useful in older statutes by setting out the purpose. We've also got extrinsic aids. So these are matters outside the Act that help explain meanings of words in them. So some examples of extrinsic aids are dictionaries that are up to date at the time of the case. Hansard. So this is a transcript of parliamentary debates. So Pepper v. Hart is a case for that. However, it's only considered when words in the Act are ambiguous or obscure that lead to an absurdity. You also got legal aid handbooks, other acts, international treaties, and law commission reports. Now, another subtopic is statutory interpretation rules. Now, one of these rules is called the literal rule, which means applying a statute word by word using the dictionary version of each word without embellishment. So Cutter v. Eagle Star is the case to use there. It follows the exact words of Parliament, so there's no room for judicial lawmaking. It must follow Parliament, so lawmaking is left to those democratically elected. Words are also given their ordinary and grammatical meaning, so it's more certain and predictable outcomes, and lawyers can better advise their clients then. Also, using the literal, it highlights problems to fix, which leads to reforming the law. However, the words can be outdated and have more than one meaning, especially in some dictionaries. Professor Zander said the literal rule was irresponsible to use. It can sometimes lead to a complete defence. Absurdities and unjustness and technicalities are not always intended. You've also got the golden rule. This is a literal judge who wants to avoid absurdity. Now, there's two applications for the golden rule. Firstly, you've got the narrow application, which has two possible meanings, but the judge chooses the less absurd one, so R.V. Allen. And you've also got the wider application, where there's one possible meaning. This is because the judge modifies or clarifies the term to produce a less absurd outcome. So Allen v. George, or Adler v. George. It allows the court to make sensible decisions. It prevents Parliament having to pass legislation. It respects the authority of Parliament. However, judges can change the law. It's quite undemocratic. You can use Zander feeble parachute argument. And it's unpredictable as it lacks guidelines. Penultimately, you've got the Mischief rule. Now, this gives the judge more discretion. As shown in Hayden's case, what defect/mischief in common law was the statute trying to rectify? The court can then interpret it in such a way that the gap is covered. You can use Smith v. Hughes for this, or Royal College Mersing v. DHSS. Now, Hayden's 1584, this is where the judge considers the position of the law prior to the act, the defect designed to remedy, Parliament's intentions, the true reason for the remedy. The words are then interpreted to best suppress the mischief and advance the remedy. Lastly, you've got the purposive approach. So this looks at what Parliament wanted to achieve. So the intention of words that are put into bills aren't really considered an issue. This approach is preferred by the EU and the ECJ. English courts therefore use it when applying EU law. Most EU member states have adopted it. It's used when applying HRA 98 to legislation. Courts are under obligation to ensure that the English law is compatible with the EU Convention on Human Rights. Some cases to use there are Jones v. Talbot and RV Register General Ex parte Smith. Evaluating this, it gives effect to Parliament's intentions. It allows judges to use their common sense. It's sensible to use external aids like Hansard. It makes sense to look at what the whole purpose is of acts. However, finding the intention is sometimes hard. It's undemocratic, and it can lead to uncertainty if the judges change the meaning of the statute. The next topic is judicial precedent. The first subtopic is binding precedent. So some keywords that may come up. You've got judgment, which is the ability to make a considered decision or come to a sensible conclusion. Ratio decidendi, the reason for deciding. Obiter dicta, other things said. You've got original precedent, binding precedent, and persuasive precedent. Another subtopic that comes under judicial precedent is hierarchy of courts. So in the following order, you've got the European Court of Justice, the Supreme Court, the Court of Appeal, the Divisional Court, and the inferior courts. So they are bound by courts above and their own past decisions. However, there are exceptions to this. So, for example, in the Supreme Court, they use what's known as the Practice Direction Statement from 1996, which allows them to depart from their own previous decisions when it's right to do so. The case to use for this is Harrington. That's one of the first cases. Court of Appeal judges are also able to ignore judicial precedent because of the case of Young v Bristol Aeroplane Co. 1944. Now, for this to happen, there are 3 exceptions that must be met. So there are conflicting past decisions. There is a Supreme Court decision which effectively overrules the Court of Appeal decision. And the decision was made by incurum, which means error. There's also an extra exception for criminal cases. So R.V. Taylor, 1950, so this is misapplied or misunderstood. Another small subtopic is law reporting. So this outlines key facts and legal principles decided. The system only works, however, if someone reports/writes it down. So for example, some of the more well-known law reports are the All England Law Report, which is in the Times. There's also ways to avoid precedent. One of the ways is distinguishing. This is the method of avoiding a previous decision because facts in the present case are different. So the cases that illustrate this is Balfour v. Balfour, not following Merit v. Merit. You've also got overruling. So the decision which states that a legal rule in an earlier case is wrong. So Pepper v. Hart, the House of Lords overruled Davis v. Johnson on the use of Hansard. You've also got reversing, where a higher court in the same case overturns the decision of a lower court. But however, this only happens if there's an appeal in the case. Looking at the evaluation of judicial precedent, starting with the advantages, you've got certainty, as it helps advise clients. There's consistency and fairness in the law. Also, there's precision, as it provides detailed rules for later cases. Also, the law is quite flexible, as it's able to update quite quickly out-of-date issues, and it's time-saving. However, some complaints are that it's quite rigid. It can lead to bad decisions that are difficult to change. Also, the complexity. There's a number of decisions made and different reasons given for those decisions. Logical distinctions, slowness of growth, and expense of actually having to go to court. Also, it could be argued it's undemocratic, as judges shouldn't be able to change old precedents. Now this brings us to the end of Paper 2, Section A. If you've got any questions, just leave a comment down below and I'll try and get back to you as quickly as possible. I'll be releasing a couple more videos, so tune in for them. Thank you for listening.